Yes, call the list. Okay. I'm for the respondent.
Item number 1, I am appearing on behalf of the petitioner lordship. Since the service is not complete, I am praying 1 week accommodation.
The learned advocate for the writ petitioner. One week has to be after vacation.
Yes.
One week. Good.
I am grateful, lordship.
Item number 2.
Yes, Milord. This is my application, Milord.
Yes, sir.
Yes. Yesterday, Milord, I sought leave from your lordship. Your lordship, so kind enough to grant me. This is Milord in.
Oh, yes. That appointment matter.
Yes, yes.
Yes, sir.
Yes.
We asked you to see some
Milord,
judgment also
Milord,
yesterday.
yes, 2020, volume 6, SCC,
Page 1.
1, paragraph 392. And there I have also found Milord, another judgment, 2020, volume 6, 1. It says that litigant cannot. Judgment is denied.
Oh, that is the same judgment.
Yes, yes. 2026, which your lordship, Milord, yesterday, Milord.
Or 26.
2020, volume 6.
That is the Roger Matthew one.
Yes,
Yes.
yes, that's this one. And thereafter, Milord, the another judgment, 2003, volume 6, SCC, page 581, para 25. 3, volume 6, SCC, page 581, para 25. I will hand up. Kothay?
Is it considered in 2020 volume 6?
2003, Milord, not 2003. Yes.
Before Roger Matthew.
So before Roger Matthew.
So therefore, we are saying, is it
Yes.
considered in 2020?
2020, Milord, 2020, 6 SCC, page 1.
That has considered 2003.
Oh, no, Milord, possibly. Both are in the same line, but this was not considered.
You have seen, it is not considered. So that way, what does that say?
Milord, it says, Milord, it is unfortunate that the authorities concerned are not making the administrative tribunals under the Administrative Tribunals Act 85 functional and effective by appointing men of caliber. It is for the High Court to see that if the administrative tribunals are not functioning, justice should not be denied to the affected persons. In case the administrative tribunal is not functioning, it would be open to the employees to approach the High Court. Milord, this is in the context of a Milord case.
Trying to keep our head cool.
It's already cold.
They are trying to keep our head very cold.
Your lordship is always.
I don't know. Yes.
Milord, 2003 6 SCC that was passed in the context, Milord. There was, Milord, agitation, Milord. In block employees, Milord, were suspended from the Tamil Nadu government. Milord, they questioned, Milord, the proper 2026. So, Milord, that is the context, Milord. Ultimately, Milord, they directly approached, Milord, the High Court, and then, Milord, it was found the Supreme Court, Milord, had made this observation in para 25. But ultimately, it is a doctrine of convenience, because your lordship, while dealing with another matter, Mr. Basu Mallik was there. Your lordship had specifically asked Mr. Basu Mallik and Mr. Mukherjee, my learned senior friend, Milord, he is not innocent of fact, but although, Milord, he no, he identified. No, my lords, no. Yes. Mr. Mukherjee, Milord, in his usual fairness and, Milord, the confidence submitted, Milord, that the file was sent to the governor. It was not possible for him to know that what was the next step. That is true. The tribunal, Milord, that is why your lordship specifically asked, and your lordship disposed of one matter, directing the tribunal to dispose of the matter within a certain period. Request. Normally, your lordships do not do this, because in a situation like this, Milord, because I specifically, Milord, expressed my apprehension that the government will not do this. Even then, my lord, this honorable court feels that no, since the specific submission has been made, that was all, my lord, the verbal, my lord, nothing on record.
Yes, we remember he had
Yes,
told us that
yes,
it is
yes,
now
yes.
lying.
Yes, and Mr. Basu Malik in turn, my lord, he was on a virtual mode. He said that the file has already been sent to the Honorable President of India for appointment. Be that as it may, my lord,
So there is a further development.
further development on that date it was disclosed. Be that as it may, today it is not functioning. This is one part of the story. So, my lord, I came before you. Yesterday I approached your lordships, my lord, that in absence of any, my lord, adjudicating authority, my lord, that my right to approach, my lord, which your lordship, it was, I was not, my lord, it is my fault that I, my lord, did not go through this judgment, and this paragraph 392, it lends, my lord, meaningful assistance to the lease, and it exactly, my lord, on the point.
That 392 is his lordship who has slightly deferred with the majority view.
Yeah.
This is the majority view on this aspect.
That is not it. The L. Chandrakumar, which your lordship yesterday, my lord, may I only take, my lord's valuable 5 minutes time. The litigants cannot wait for judicial impact assessment and action by the government, which may or may not take place.
You are reading which
Experience?
You are reading from L. Chandrakumar.
No. 2026. Consider.
Roger
Chandrakumar
Roger
consider.
Matthew. Which
So, yes.
which paragraph?
392, which your lordship referred yesterday.
No, that we have
Yes.
that I remember because I
Yes.
had referred to you yesterday.
Yes.
What I am saying, what we are asking you is on this 392 is a part of the judgment of the honorable judge who has slightly deferred on certain aspects with the majority view. He has agreed with issues 3, 4, 5, 6, 7, 8, but the rest he has expressed his own opinion. So what is the majority view as regards this aspect? You have the SCC.
The concurring view.
You have SCC.
Yes. Let the concurring view, Justice Deepak Gupta, my lord, having a two-tier tribunal system like United Kingdom, having one appellate forum within the hierarchy of the tribunals would probably lessen the burden of the High Courts and Supreme Court.
See, we are troubling you because now this issue is going to come up every day because the tribunal is not there. Therefore, we are asking you to
Yes.
please assist the
Yes,
court.
yes. My lord, the first of all, my lord, the issues arose for consideration. In the context, my lord, the court had come to a conclusion. Whether that was the Finance Act insofar as it amends certain such and such the condition of persons manning different tribunals can be termed as money bill under Article 110, consequently validly enacted. If the answer to the above is in the affirmative, then whether Section 184 of the Finance Act is unconstitutional on account of excessive delegation. Then, my lord,
No, that we
the fifth point, whether there is a need for conducting a judicial impact assessment of all tribunals in India. Then, my lord, whether judges of tribunals set up by acts of parliament under Article 323 or 320 can be equated in rank and status with constitutional functionaries, whether direct salutary appeals from tribunals to the Supreme Court to be occurred, whether there is a need for amalgamation of existing tribunal and setting up of benches. Answering the questions in terms of the Supreme Court held per curiam genesis of tribunalization, then, my lord, it says the majority view. না বইটা হয়েছে কি we have এক সেকেন্ড হ্যাঁ Milord, para 46, I do not know, Milord, whether this is the, Milord, the answer to your lordship's query. It says, Milord, after the court 45 and 46, the court found many tribunals failed the test of public confidence due to purported lack of competence competence, objectivity, and judicial approach, the court thus called for drastic measures to elevate the standards of tribunals in the country. It was also reiterated that the exclusion of judicial review by high courts were impossible, providing direct salutary appeals to the Supreme Court impeded the common litigant from exercising his right to appeal, because the exercising the short term of the members and lack of judicial experience of non-judicial members, the need for establishment of an oversight mechanism to review the competence of all persons manning tribunals was emphasized. Thus, it was suggested that all the tribunals be brought under a single nodal such and such, most appropriate the Ministry of Law and Justice for overseeing working of tribunals. Lastly, however, was granted to the ministry to appoint such and such. If tribunal are established in substitution of courts, they must also possess independent security. Then it comes Madras Bar Association's case, and then
You have the.
Then para 152, a tribunal constituted in substitution of any other court should have similar standards of. Then tribunals are reasons for
See, what we are pondering over is an issue covered by issue 7 of that judgment. Now, issue 7, as far as what we can see right now, subject to whatever you may point out.
7 whether direct salutary appeals from tribunal. That is the.
So that covers. It is in that context that the honorable judge who has made that observation in 392.
392.
So that has been dealt with and appears to be from para 214 to para 217 or 18, 214 to 218. So that 392, if at all, it may be supplementing this, because on that issue he has concurred with the majority view, insofar as issue 7 is concerned.
214.
Now this concept of
380, 381, I agree with the Chief Justice both on the reasoning and conclusions on these issues. However, if issue 4, 6, 7, and 8, 4, 5, 7, and 8, which your Lordship Miller initially referred. However, as already pointed out above, I am of the view that since nobody has raised a challenge to the correctness of the law laid down by the 7-judge bench in L. Chandrakumar, that there should be the one wholly independent agency for the administration of all tribunals.
No,
there is no need.
We are on exercise of jurisdiction by the High Court.
Yes. But his Lordship, Justice Gupta, 392, 382, I would like to add a few words because I feel that is important to highlight the problems being faced and the issues which need to be resolved.
So this is adding to which view of the majority judgment? That is precisely what we are asking you.
No, 457 is the issue, but it is in consonance, in line with 214 to 217.
214 to 218, because you see in that portion, there is a
Millard. The 7-judge constitutional bench in L. Chandrakumar considered at great length the permissibility of altering the power of judicial review exercisable by high courts under Article 226. It authoritatively held that all orders passed by tribunals which have been established under Article 323A or 323B of the Constitution shall be amenable to the jurisdiction of high courts. The court, however, in an attempt to respect the intent of the facilitating speedy disposal expressed by Parliament, directed such orders of the Central Administrative Tribunals be heard by a division bench of this High Court if challenged under Article 226. This court thus held such and such. It has also been contended before us that even
See, why we are asking you is I have not read this judgment recently. Therefore, there is somewhere I remember seeing that the majority view referred to the concept of regulatory deference by the high courts in exercise. Concept of regulatory deference as is being exercised by courts in the US. That is what I was looking.
yes. Regulatory deference in page 216 paragraph.
Huh?
However, it is essential that the high courts are use such powers
Who?
of 216 reviewed restrictively on limited grounds similar to the concept of regulatory deference which has evolved in the United States. Such a need, that is the question, my lord.
Yes.
Your lordship has already, your lordship possesses elephantine memory.
No, no, no.
216.
I was,
216.
otherwise, I would not have been searching for the last 10 minutes.
No, my lord, it was my incompetence that my lord, I missed this point. Because my lord, what happened, my lord, it is a kind of a laziness when the court, my lord, pointed out at 392, when I found it in my favor, I did not, my lord, travel, my lord, to the other paragraphs.
That we understood very
I did not. That is a shortcut, my lord.
From your,
because
from your submission.
from
Yes.
the submission. we
Yes, my
understood.
lord. 216, my lord.
We were expecting that you would come with all this.
My lord, on the eve of winter vacation, I thought, my lord, when my lord, when a professor in the class, my lord, gives a reference that it is a suggested question, answer, then my lord, I need, my lord, since 392 is exactly.
Again and again, I express my view that whatever I express should be taken as a cue to assist the court rather than feeling that it is we are
No,
trying
my
to
lord,
be
my
hostile
lord,
or-
what happened, my lord, I tell you, lordship, my lord, in my humble way, my lord, as I've understood, my lord,
I'm not
390.
used to being a mute spectator in court.
No, it should not be. My lord, it would lead to the travesty of justice, my lord. The bar and bench interaction is essential, my lord, for the ends of justice. Now, my lord, 216, which while jurisdiction of the High Court, Mafatlal Industries, my lord, the under Article 226 and of this court cannot be circumscribed by provision of the states.
This paragraph.
216. So, my lord, now may I go to the facts? My lord?
Yes. Every day for the last 2 days.
Yes,
I have
Malam,
been
because
asking
the,
the part.
the tribunal is not functional, that's why these cases are coming.
And in one case, we wanted to adjourn the matter or remand it back to the tribunal. Then the learned AGP said that it may be kept here because we don't know when the tribunal will start functioning.
December was, according to his perception, is a
In that case, he suffered an interim order, so he said, no, keep it here because we don't know when the tribunal will start. So what are the facts?
the facts, my lord. The petitioner before your lordship, my lord, he graduated MBBS in 2003. And thereafter, my lord, he obtained DNB degree in the discipline of general surgery from Central Hospital, my lord, Southeastern Railway, Kolkata. Now, my lord, presently he is posted as Associate Professor, Department of Surgical Oncology, IPGMR, and SSKM Hospital, Kolkata. Now, my lord, his first appointment as RMO cum clinical tutor in the Department of Surgical Oncology in the Medical College Hospital, my lord, and this joining of the petitioner was during the transition period of 10 years of the specialized fees. What is the transition period? In the context of the rule, I will come. Joining report, my lord, is there. Petitioner ultimately was promoted to the assistant professor through departmental promotion, and thereafter in 2021 promoted to the associate professor by an order dated 26/11/2021. That is also a part of record. Millard on 6 July 2022, he was transferred to as an associate professor to IPGMR SSKM. He was appointed as a member of Board of Studies, Millard Surgical Oncology. Millard, there is a departmental notification. Notification was issued by the Director of Medical Education on 1st December 2025, declaring the departmental promotion for the post of professor, associate professor, and assistant professor as per the list of the vacancy cut-off date for determination of eligibility, which is at Millard, page
131.
Yes. One vacancy for the post of professor in discipline of surgical oncology.
Which page?
Millard, para 8 is the averment and page 31 is the 112/2025.
No, that list, where is the list of vacancies?
35.
All right, we got it. Surgical oncology.
Surgical oncology, 35/6 from bottom. Surgical oncology, one post, page 35. After Millard, surgical gastroenterology. My lord, got it?
Yes.
Yes. Now, Millard, while attempting to apply for the promotion through online portal, Millard, being the Faculty's Information System WBMAS, maintained by Millard Health and Family Welfare Department, Government of West Bengal, Millard, I was unable to complete the process as the online portal demands the degrees of MCH or DRNB. That is the super specialty degrees in surgery, which are not my degree, because my degree is DNB, Diploma of National Board in the discipline of general surgery. I request my lord with humility to come to paragraph 10 of my lord of my petition. Paragraph 10 of the writ petition.
Yes, we just saw it. So you say that there was some
I said,
relaxation given to you.
Yes, teachers eligibility qualifications in medical institution regulation 2022. And it is that Millard, it says Millard, it gives me Millard certain protection, and I enjoy the protection under, that is what page paragraph 10 of my writ petition. That is Millard a specific pleading which Millard possibly lends meaningful assistance Millard to my lord to decide the case. May I read for my lords Millard? It is pertinent to mention here that the petitioner joined the Medical College, Kolkata RMO clinical tutor in the Department of Surgical Oncology during its transition period, that is during the first 10 years of the newly instituted super specialty course. The petitioner joined by dint of relaxation of qualification and experience during such transition period as enshrined in minimum qualification for teachers in medical institution regulation 1998, as well as in the amended notification of 2022, being the teachers eligibility qualifications in medical regulation 2022. It is pertinent to mention here that clause 7.2 of the said notification specifically mentions that persons appointed as teaching faculty during the transition period shall be eligible for promotion to the post of associate professor / professor even after the transition period of 10 years are over. Such person shall also be entitled to hold the teaching position held by him until the age of 70 years in the same or any other recognized medical institution, thereby guaranteeing the eligibility for subsequent department promotions in the discipline by dint of the qualifications so possessed. It is further pertinent to mention that clause 14 of the said regulation specifically states that notwithstanding anything contained in the said regulations, any appointment made under the minimum qualifications for teachers in the medical institution regulation 1998 or the recommendations of the council prior to that would be protected. So, Millard, I refer Millard, and may I hand up Millard to the regulation in order to Millard eradicate any doubts, if any.
So you have quoted clause 7.2.
Yes.
At page 7.
Yes.
So perhaps that is what you are relying upon.
Right.
So, but then the
regulation 2025, which
so there is a subsequent regulation.
Yes, 2025. That is Millard. Judge Sahib ke deben. Millard, if your lordships kindly take pain, Millard,
Just give us a minute, please.
I'm sorry.
Look, I'm sorry for the International Medical Commission is a necessary party. The regulations are being placed before lordship. It is a necessary party because the government has followed these regulations of National Medical Commission. They are a necessary party.
Let's see. So this regulation specifies the super specialty qualification.
Yes, and protected.
And this, how does this acknowledge 7.2?
Yes, 7.2 acknowledge, because the recital of this, Millard, starting point, Millard, I'm grateful to your lordships. Whereas the teachers' eligibility qualifications in medical institution regulations were notified in the website of National Medical Commission on such and such date, inviting suggestion and objection from all persons likely to be affected thereby within 30 days from the date on which the copy of the said regulations were made available to the public. And whereas the objections and suggestions received from the public on the said regulations within the period so specified have been considered by the Commission. Now, therefore, in exercise of the powers conferred by Clause E, C, subsection 2, Section 57 of the National Medical Commission Act, read with clauses B and C of subsection 1 of Section 10 of Clause F of subsection 1 of Section 24 and Clause E of subsection 1 of Section 25 of the Act, and in supersession of the teachers' eligibility qualifications in medical institutions, Regulation 2022, except as respects things done or omitted to be done before such supersession, the National Medical Commission hereby. Here is the protection. Clause 7.2, your lordship's answers, questions, Milord, has been answered in the recital. That
So
is
there
the
is an
recital.
exception clause. Although the qualification has been
Yes.
laid down, but acknowledging whatever has been
Yes,
done.
retrospective operation clarified. It is a clarification that protection, like a saving clause, Milord.
Clause 6. General Clauses Act.
Number one. Now, Milord, what is my point today? Point is not that I'm agreed by the 1/12/2025.
So what is the relief that you want in the writ
I
petition?
wanted 24/12/2025. Tomorrow is the last date for
No,
filing.
what is your main relief in the writ petition?
Participate. I want to participate in the selection process. You are not allowing me. No, promotion. Online application that has been, I was prevented. What is my prayer?
D. Allow the petitioner to participate in the department.
They are not. I am a paper settlement.
Participation will not create any equity in students or so he has to seek some substantial
By regulation, and Milord, your lordship's query, I request my lords with humility, kindly turns me Lord page 9, paragraph 6 of my writ petition. Page 6, paragraph 9. I read for my lords. Page 6, paragraph 9.
No, what we are trying to see is what is the substantial relief in
Really,
aid of
the-
which the
the
interim
petitioner-
relief has to be passed.
Milord,
Has to be
I
given.
only, Milord, pray that tomorrow is the last date for filing application and they are not allowing me, considering 2025 regulation, and which mandates that the petitioner is not being able to complete the process as the said online portal demands degree of MCH or DRNB, that is postdoctoral super specialty degrees in surgery which are not possessed by the petitioner. It is pertinent to mention the petitioner
Does
possesses
the advertisement give any acknowledgement to clause 7.2?
yes, page 30,
31, page
page
31.
31, T1. কি করেছিস এটা departmental just a minute. No, last eligibility criteria, paragraph 13, page 33. Eligibility criteria and qualifications as per extant MCI NMC regulations.
Page?
It starts from page 3.1 and 33 bottom, clause 13. And 12 also, Milord, it depicts the trajectory, that how it to be accorded, Milord, the decision, clause 12, but 13, Milord, and Milord, in order to lend meaningful assistance, I request your lordship to come to Milord 42, and 42 is absolutely clear, Milord. 42. It is a general portal of the WB respondent.
We have understood what you are saying. We are saying, is this the substantial relief in the writ petition to allow you to participate?
Yes.
Just to fill up the form?
Yes, they are not allowing me because I cannot, because clause 12 I have shown that it will be considered because I am competing with others. Only
Clause 12 of?
Clause 12 of the Milord, how it is to be done of the page 33. And before that, Milord, kindly come to Milord, page 42 first. Page 42, Milord. Page 42 to page 42.
I declare that I fulfill the eligibility
It
criteria.
says, my lord, I declare that I fulfill the eligibility criteria for promotion to the post of professor, associate professor, according to the minimum qualification teachers for teachers in medical institution regulation 1998, amended by the Board of Governors in supersession of the Medical Council of India, notification dated 14 February 2022, 7.2 I have shown. 7.2 has been taken care of in 2025.
So this is from the portal. There is an option.
Total categorical declaration. This is a declaration. I have to declare. Declaration. That declaration, because this declaration, my lord, corroborates that 1998 regulation, 2022 regulation, 2022 regulation 7.2 has been taken care of, my lord, while, my lord, introducing, my lord, 2025 regulation. The recital says except as follows. So today, I cannot say only one post, because this regulation protects. And this is not out of serendipity, my lord. It is a question, my lord, that the rule-making authority was very much conscious about the choices they had made, my lord. It's a conscious choice that these categories of the candidate who had rendered their
Is there anything in the advertisement at page 31 talking about the 22 regulation?
extent, last paragraph 30, page 30, extent, MCI or MC, NMC. So today there is no conflict with the advertisement. Today there is
So actually there is a
Extend mean thesis. Extend mean thesis. It is June, it is December.
qualification as per extant MCI NMC regulation. So this is
Extend means 30th June 2025.
extant regulations. Yes, yes. If that is so also, that regulation says I am protected. That is also protected. Things done under 2022. Otherwise, when a law becomes not meaningful. No?
As respects things done.
Yes.
So he says, so regarding. Yeah, no, my lord.
Mr. Also, my lord, the normal Miller opposition Miller which state takes, either it is not maintainable, or Miller the second point comes Miller that the necessary party or service not completed. So Miller, to this Miller, with humility I submit Miller to the my
I
learned.
just opened my mouth.
No,
and
no, you know you have said.
he's
I have uttered.
preempting certain
No,
submissions
no,
from the-
he has uttered few minutes ago, my lord. I hope he must stick to his principle, my lord, that whatever I have uttered in the court, that is true. He said NMC is a necessary party. Necessary party is a concept, my lord. I, my lord, do not want any order against NMC because I rely on the NMC regulations. I am protected by the regulations. I am protected by the advertisement. If that is so, why there should be an unnecessary challenge to be thrown? I am only saying.
Challenge. I'm saying that this is a
No.
necessary party
No,
because this is based on the NNC regulation.
no, I am not saying. I said.
what he is, if we have understood his case, what he is saying is the NMC perfectly recognizes me as an eligible person. There is a clause in the advertisement which allows me to select that I am one such person who is qualified under 22 guidelines,
Deeply obliged.
but the technology has barred me.
Now, my lord, Lordship, my lord, may I assist to Lordship now? Your Lordship has heard Mr. Basu, Lordship, kindly hear me for a few
If
minutes.
this is the substance, perhaps. Yes.
Now, my lord, Lordship, kindly have a look to page 31 once.
Yes.
This is the advertisement. This is the 1st of December
I
2025.
apologize for a moment, my lord. I tender
Yeah,
my
what-
apology. Sorry. No, my lord. No, my lord, I'm sorry. I do not have that audacity, my lord, to prevent a unless government period of the High Court.
No,
I
but-
only say, my lord, if the court passes this order, my lord, which I am praying,
So we'll see everything.
yes, how the government is.
How that will bar, that will not create any right in his favor.
Yes,
You allow him to apply and we'll hear the matter. You may file your opposition. Because there are many steps to be taken from the advertisement we are seeing.
Now, my lord, this
There
is
is-
portal based. Lordship, kindly bear me for a minute. Lordship, kindly have a look to page 31.
Yes.
The advertisement is the 1st of December 2025. He came to this honorable court. Now, he only
He wrote
yesterday-
twice to you. He wrote to you twice. You could have rejected. He has written to you twice.
Lordship, kindly see, my lord, Lordship. Yes.
Just see two representations from 1st till 8th.
Lordship,
18th.
kindly see, my lord. This is portal based.
That's why we are saying. That's
But
why we are.
this is done online. The question of rejection comes, my lord, after the if it is done within the time frame, then Malad, this is not required.
Because see, there are many steps to be taken. Vacancy list will be declared.
Yes, Malad, I just immediately said to
So
Lordship,
nothing is going to happen immediately,
Lordship.
but the last date for applying will lapse. That is the only thing.
Lordship kindly says, that is his admission also in paragraph 9. He says that I am not.
Yes, he is not saying otherwise. He has
And
said so.
Lordship kindly have a look, Malad, that an exception has been sought to be carved out in the regulation of National Medical Commission. Lordship kindly says, Your Lordship, I hope Your Lordship has the copy, Malad, of this.
Yes, he has given us a copy.
Lordship kindly, Malad, the second paragraph, third paragraph,
Yes.
Malad, the last part, except as regards things done or omitted to be done before such superstition.
Yes. So
Well,
before such supersession, you have appointed him. He says you have appointed him by relaxing his qualification to attain an objective of introducing some specialized education.
Qualified. He's not qualified under this.
Then we don't know. That is not the issue before us right now. Right now, the only issue is whether he will miss the opportunity or he will apply. We don't know what will happen. Maybe we may agree with you after the holidays. We don't know. We are not deciding the issue today.
So
And I
I want to lodge the observation. Only he wants participation because
Yes,
it is tomorrow.
last date is tomorrow.
Yes.
That
But
is
my question is why he has come on before the last date?
No, that we have seen. So we are telling you, he has written to you twice. Why you took no steps?
Well, Lordship kindly says I did not because the portal is
So
operating.
you could
now.
have told him that we will not do it.
No, that I cannot say because I can say only after the time.
Only
frame
after
is
the time
complete.
has lapsed.
After the time frame is complete.
So that we'll consider. You allow him to apply, whether you allow him by giving him a window online or you accept it offline, however you want. You do it however you want. That option we'll leave to you.
Now, but so far as the point that your Lordship is taking up the matter because the tribunal is non-functional, but I am not standing in the way. But because it is a fact, I can't improve upon it. The tribunal is not functioning.
Yes.
So, your Lordship can take it. So, I have heard Mr. Submission, Mr. Basu. Now, your Lordship kindly sees that. What is this? What is this? I am addressing the court. Don't laugh. Now, your Lordship kindly sees that here, Lordship kindly have a look. I don't know, the page 30. Yes, page 36, Lordship kindly have a look. Page 33, first of all, the page 33 of the advertisement. But eligibility criteria.
Mr. Datta, we will consider all these aspects and we will allow you to file an opposition. We have seen from the advertisement as nothing is going to happen in a week or so. You still have to identify the vacancies and everything. So why he should miss? Let him apply. It will be subject to result.
Without
We'll hear everything.
equity
Obviously.
in his favor or very well.
Obviously, yes. The issue
I have a plain copy of the order so that I can.
Who is the respondent competent to do this?
DME, Director of Medical Education.
Respond number
Two.
We direct respond number 2.
Application, participation.
Just read.
We need that.
We direct respond number 2. Respond number 2. What?
Respondent authorities.
State of authorities. State
Authority
respond number
to
2. Just a minute. Just a minute. The first issue का नहीं लिखे हैं. The first issue is two weeks as prayed by petitioners.
টোয়েন্টিয়েথ জানুয়ারি 20 তখন স্যারের নামটা কত দিয়েছে 3 তারিখ দিয়েছে 3 দিয়েছে
Or my lord, I am for the petitioner. My lord directed last time that opposition be given by the state. এখনো আসে make it peremptory because I have been suffering since 2013.
Your debt petition is of 25.
Petition is of 25.
What happened?
We have informed the director. Kindly take it up one chapter. In the meantime, we will find it.
Not 12, it has to be 13.
12 এ ছুটি
19
holiday.
19th.
No, instead of 19, can you make it 20?
Yes, 20.
Correct.
20.
Item number 5.
That I might reply.
Where is the order passed in OA 913? OA 913 of 21, it was filed by you earlier. Where is the order passed there?
Page 93.
Where is your representation? After this order?
Presentation, my lord, next page, my lord, 96. I have to have the copy of the reply to the my lord, advocate appearing for the state, my lord, that I could not be. My lord, says, my lord, the same is affirmed only yesterday. Same is, my reply was affirmed only yesterday. That is why I could not be served the respondent, state respondent, my lord. I have to point it out, my lord, your lord. Oh. But no one is appearing also. My lord, reply, lord. Who is appearing for the state in this matter? Whom you have served? Corner I Chaudhuri.
What is the name Cornera Chaudhuri? She has been depaneled last. Right now, fresh service once again has to be executed for further allotment. এটা আপনাকে বলে দিলাম, Cornera-
You have to take information and you have to serve a PDPD reply upon him or her.
What is your right? Let us see your right first.
The right means, my lord, I was appointed in the year 2000, my lord.
Appointed or engaged?
That was engaged. The letter was issued, my lord. Actually, it is appointment, but my lord,
Why they should declare you a permanent staff? Why? What is your right? That is what we are trying to understand.
my lord, I have been rendering my service
Many people like you.
as a regular employee, my lord. And all the
Then be happy. Then why would you, then nothing is required. If you are regular employee, then be happy.
all the duties and responsibilities, working hours,
Therefore, we are asking you, what is your right?
my such.
What is the right that is to be enforced by issuing a positive direction in a writ petition or by the tribunal?
My respective submission is this,
There has to be an existing right, then only such a direction can be issued. Where is the existing right?
My such work for last 25 years accrued my right that I has to be regularized.
You are getting the benefit, you are getting benefit of a fixed pay.
My lord, all the except some incremental benefit.
Correct.
Other all the benefits are, my lord, they have been allowing, my lord. Even ROPA also.
It's up to 60 years. Whether that benefit has been given.
My responsibility is a camouflage.
Oh,
nothing
that benefit of 60 years, up to 60 years, that benefit has been given to you.
No, my lord, that was not given. My lord.
Where is that statement in your OA? Show us. That has been given to you, sir. You have stated that you are getting a fixed pay. That means the benefit of that government policy has been extended to you, which contemplates fixed pay, leave, continuance till the age of 60.
That is why, my lord, I have, before your lordship, that they have actually treating me as a matter.
What remains?
By going a circular, my lord, since my very inception of my service, they are treating me, my lord, delegated employee, whole time delegated employee.
Where is that circular?
My lord, circular 73, memo number 7373, dated 28 July 1999, Finance Department, my lord.
99? How 99 will apply? You have come into this establishment in 2000.
That they have applied against me, my lord.
How it can be applied?
My lord,
You have come in 2000. That will neither apply for you nor against you.
that is my lord. Respective submission also before your lordship, my lord.
Where they have applied the 99 circular upon you? By which decision?
My lord, my engagement letter, my lord. And the appointment letter.
Sir, we are asking you when you got the benefit of the fixed pay and other benefits. Where is that decision?
I kindly come to page 55, my lord. Page 27. With reference to your application dated 9th March 2000, I am directed to inform you that you are engaged as a group P employee.
Correct. Therefore, we asked you, you were appointed or engaged? You were never appointed. You were engaged. We asked you, that was the first question.
Establishment, but not
There is a
throughout
big
the year,
difference between appointment and engagement.
but not throughout the year, to be paid out of contingency in terms of clause B of memo number 7373.
So when you were conferred with the pay package, show us, where is that decision?
Whether you are engaged against a permanent vacancy, sanction post.
No, nothing.
So that the
No advertisement, nothing. No sanction post.
this department was established in the year 2000, my lord. Just to control the said department and for their own benefit, they have engaged me as a group employee.
When a department has been introduced or created, then the post for that department must be created.
required to be
So
created.
certain numbers of posts were created by the department.
Are required to be
Now-
created, but government has not created the same since.
Now
They
we are
have-
not.
They got some employees to run that entire units.
Like you,
Losses.
and one of you got inside, maybe 1 lakh people were outside because they were not fortunate like you to submit an application and get engaged without any advertisement. There may be 1 lakh people like you who were outside.
Application was made by that for a.
That is what we are saying. You make an application, you get an appointment, engagement, and lakhs are staying there. They are getting nothing.
But the application was made by
Your service should be regularized.
53 minor.
You have no case, sir. Sorry. When did you get the other benefits? At least show us that the fixed pay and age of 60 and all.
Page 38 minor. 58.
58.
Existing terms and conditions and as usual they will draw pay of rupees 660 PV number 1
What
plus.
is that?
Get paid.
What is the date of that circular? It is of 2016 or something. We have seen it.
15 most probably.
Pay now I am getting the
Under which government decision? That is what we are asking.
the charge shall be debited from current account number such and such. The current finance department should do all that. But possibly an order issued for such payment dated 7th October 2020. My lord. Well, I have to, well,
There is a government policy. In furtherance of that policy, you have been granted this benefit. That policy is of September 2013, 14, 15, something like that. Where is that policy?
that I have to collect my lord.
The record that you are getting that. That's why we
It
are.
was not the part of the my lord way.
At least that what you are getting will be protected. Therefore, we are asking. Where is that?
That's to my lord. So that I allow to for that.
Krishna has
2-0. Item number 6.
Malad, in item number 6, I am appearing on behalf of Public Service Commission.
Whether this matter that on the earlier occasion your lordship wanted me to place certain law, satisfy your lordship on the point that whether the employer they can fix the number of candidates from the written test who have appeared in the written test and who have been called for the interview in violation of the earlier ratio followed by the same employer and on the basis of clause which says that only they can call on the basis of the reasonable limit.
Call on?
Reasonable limit. The number of the candidates, the petitioners.
No, it is your case that they should call more people, then you will become successful.
Yes.
So we asked you show any judgment to support your contention.
Yes. Before I enter into that judgment, I want to draw your lordship's attention.
Yes, there is a number of candidates is increased.
It will result in lower down.
It's only an issue whether the law permits passing of such an order or you have any right to claim such a direction.
Yes, madam.
So therefore we ask you show a judgment, then every candidate can come that increase it some more, I will also qualify.
Yes, madam. But kindly come to page 57. I will indicate the rule and then I will place one judgment. Page 57, lordship, here in the information brochure.
What is reasonable? Reasonable by your perception or the employer's perception?
That perception has to, that is the test which is laid down in Ashok Kumar Yadav also.
What does Ashok Kumar Yadav say? Let us come to that. We have understood what you are saying.
Sir, kindly. No. I got. I refer to paragraph 32 first. And lordship kindly come. We accordingly allow the appeal set aside the judgment of the division bench of the Punjab and Haryana High Court and reject the challenge to the validity of the selections made by the Haryana Public Service Commission to Haryana Civil Services Executive Branch and other allied services. But in view of the fact that an unduly large number of candidates were called for interview and the marks allocated in the Vibhavasi test were excessively high, it is possible that some of the candidates who might have otherwise come in the select list were left out of it, perhaps unjustifiably. We would therefore direct that all the candidates who secured a minimum of 45% marks.
So in this case, what is your minimum marks?
Now they have, that is my point, my lord, they, in the judgment itself, judgment of the tribunal, which says that minimum marks was 66 point something in case of the general, or you will find it from the judgment, which is in page, for the general it was 66.75 and for SC, ST.
So it should be brought down to what level according to you? Instead of 66, what should be the reasonable cutoff marks? And are you in a position to make any such suggestion regarding cutoff marks?
No, I am not. But what I am in a position to show.
Have relied on a judgment, therefore we are making this query.
Yes, madam.
The judgment is under a different conspectus altogether.
So why not?
There the marks in interview was excessively high. So to balance that, the Supreme Court said 45% is the qualifying marks and accordingly you recast the panel. There is no such case here.
My lord, kindly read this number, compare this number.
So why not, if you say, do you know how much you have got?
Yes.
So if just to accommodate you, you should bring the number to that position. The person who is below you, if he comes, then why not up to his position? Why not?
My lord,
And where do we stop?
if I,
As a court, where do we stop? And can we lay down such a marks for every
whether-
candidate who comes?
Sir, it is reasonable to fix such a high marks.
What is reasonable? First thing is, what is reasonable?
That's why, Lordship, I want your Lordship to go through
This is nothing.
their own definition of reasonableness. It has to be looked into, read with this clause, which permits them. Lordship, kindly come to page 57 once.
Yes, we are at page 57. You will rely on clause 4.
Yes.
We know,
prescribed
therefore we are saying.
qualifications
Yes.
Are bare minimum and mere possession of the same does not entitle applicants to be called for the interview. If the number of the applicants received in response to the advertisement is large and it is not conveniently possible for the commission to interview all the applicants, the commission may restrict the number of candidates to be catered for called for interview to the reasonable limit on the basis of either higher qualification, higher marks, grade obtained in the essential qualifications, or experience in relevant field higher than minimum prescribed in the advertisement or on the basis of the screening test. Lordship, kindly note this word, reasonable limit on the basis of either higher qualification. This is not a case. Higher marks or grade obtained in the essential qualifications or experience in the relevant skill. They have not done that.
It is not higher marks obtained. It is higher marks or grade obtained.
Well, kindly come higher marks
Or grade.
grade obtained in
So
the
higher marks
essential
is also a
criteria.
Yes.
Obtained in essential qualifications
That
or
is one of
experience.
the criteria. Higher marks is also one of the criteria.
Higher marks in essential qualifications.
No.
Lordship,
Higher marks or grade obtained.
higher marks or grade obtained in the essential qualification. Higher marks or grade in the essential.
Then that slash is not existing.
I accept there is a slash. There
Then
is an or
that
grade
is one of the
obtained
that is one of the many parameters
in. Higher
specified.
marks are obtained in.
So you want it to be read that way. What else?
If I go to that in
Yeah.
that angle, then what are the
If you
minimum
go,
qualifications? Yes, we have the minimum qualifications.
Who is saying you don't have the
But
minimum?
to
Have you been excluded because you do not have the minimum
my lord,
qualification?
kindly come to this word. Obtained in the essential qualifications or experience.
So this is a discretion in the
Not the
authority.
competition.
This is a
Not the competitive
this is the
examination.
discretion in the authority to do it either by reference to the higher qualifications or by reference to higher marks or by reference to grade obtained in essential qualification or experience in relevant field higher than the minimum. So these are 3-4 options.
Now,
Because one suits you, that should be laid down. Can this be done? That is what we are asking
Lordship,
you.
I'm asking this question to myself that higher marks, reference of the word higher marks and reference of the word higher marks, higher grade obtained in the essential qualification
Yes.
and the experience can be a ground to knock
Yes,
out
any one of these. Any one of these. And it is for the employer.
They have followed
The employer has followed a uniform.
of that higher marks 66%.
Yes.
That is excessively high. Now, in this case, they have a ratio to be maintained.
Where have they laid down 66%?
Kindly come to the judgment. We came to know in the judgment of the tribunal. Before the tribunal, they revealed. Lordship, kindly come to the judgment. May I read? The applicants have filed, I'm skipping it, my lord. The West Bengal Civil Service Commission for the post of Assistant Director Agriculture. However, none of the applicants could qualify for the final round of selection. The interview.
You are in which category? Unreserved or reserved?
My lord, we here 1 is reserved, 2 is reserved, 3 is general, 4 is general, 5 is reserved, 6 is reserved, 7 is general, 8 is unreserved. They have mixed it up. Now, They fix.
We are asking you how many of all of you are of a particular group or you are of different categories.
We are in from different categories. Lordship, there are.
Then
there are
how you can be how you can claim a common relief
common relief, Lordship, on the basis of we are
for every individual? A separate cutoff should be fixed to accommodate them.
Lordship,
Then,
for the SC, there is a different cutoff.
sir, therefore we are asking you, how do you comprise a group to move the tribunal together?
Because
Can a common relief be granted to all of you?
it cannot be.
Then,
But Lordship, if they
then
choose-
which of you is going to be out of the writ petition?
if they decide, Lordship, to increase the zoning, then both of them-
Please respond to one query. Can a common relief be granted to all of you?
Lordship, since this is a challenge towards the policy,
No, it is not. It is asking the court to say that they should come down to a particular level.
because
Can a X level subserve the requirement of all the petitioners?
if they
It
reduce
cannot.
this-
It cannot. You know very well it cannot.
But Lordship, if they decide,
If and but aside, we are asking you a pointed query. Common relief can be granted to all the petitioners.
Lordship, if at all, till that limit,
Forget about if. You forget about if and but.
subject to correction.
So you are
can-
confining to which petitioner? First come to that. Then we'll proceed.
Let us confine to the petitioner number 1, Lordship.
So all others are deleted today.
Lordship, that I have to take an
You please do that. There are different category of petitioners in this application.
Item 7.
7, my lord, I am led by Mr. Ranjit Chaudhary appearing for the petition. I am praying for a short passover, my lord. He is on his legs, my lord. Short passover may be granted.
Opposition has been filed.
Yes, opposition has been filed. I will be filing my affidavit in reply. It is ready, my lord.
File it. You have served.
Not yet, sir.
Serve a copy. File it. A reply, an affidavit in reply.
19th January.
Grateful, my lord. Happy
Item number 8.
8, my lord, I am appearing for the petitioner.
Item number 8, but still there was a reject. Kindly give us 2 weeks time.
2 weeks.
Yeah.
Item number 9.
Item number 9, my lord, with the lordship kindly want to move this application online mode, my lord.
Yes,
With the
please.
lordship leave.
Yes,
My lord, my lord, this is a matter where lordship petitioner before lordship is a doctor seeking NOC. My lord, your lordship heard this matter on, my lord, on 15th of December, and my lord, there was a direction given to the respondents to take instruction whether there is an impediment or a proceeding is pending, so that all the rule provides that an NOC could not be granted. My lordship kindly have a look at the order dated on 15th of December.
Yes.
So far, certificate concerned, the government is considering can keep it on 5th or 6th January so that I can file a comprehensive report, because two judgments shall be delivered by your lordship.
Come to page 86.
Your lordship first and order.
We only allowed you time and you came back with this. In this, you want to file affidavit.
No, I'm not asking for comprehensive report because of the OBC
No, why he should miss his opportunity because you are sitting over there?
or selection process. It will take some time. In the meantime, what is the development? You will pass on the same order.
But when is the last date for filing the application?
My lord, as of now, date has not been fixed. Your lordship may get the timeline. Your lordship will fix one matter on 6th. Page, my lord, if your lordship takes the timeline issued by the end, page 48. My lord, it's all in website. Thereafter, I will get 10 days time. Basically, my lord.
So minimum 10 days from today.
Yes, my lord, that is there, my lord. And your lordship fixed one matter on 6th of, exactly same matter, my lord, on 6th of January. Now,
Five.
your lordship, 6th of January, my lord, your lordship fixed one
Let
matter.
it come on 6th. Stop.
Yes, lordship.
We have drawn attention of the learned.
Six.
113. 113. Item number 10.
10, you lot.
Yes, the structure of rules is very good in comparison to the structure of the that was in the country.
The lordship, I have
seen in few cases, basically it is nothing. Even done it.
না ওটা একটা And doctor joint interest examination. Almost best brain of our society. No. Beauty is very hard. Yes, I have a nephew. Studying material cuisine. Yes, epidemic. 113 opposites. It doesn't come for 3 days. All my duty. It's nothing. Acute fatigue of doctor. 60%. It's a national medical condition which centralized immune system. It is also necessary. But they do not consider that people doctor receive.
Yes. I am praying for not today, your lordship, on behalf of my landed senior.
Will come after the auditing.
Much obliged.
January.
7 তারিখ করে দেওয়ার message একটা।
Item number 11. They fight them.
This matter was